Thank you. Welcome, everyone, to today's webinar on presidential records and a pandemic at the Supreme Court. For those of you that don't know me, my name is Jonathan Adler. I'm the Johann Verheij Memorial Professor of Law at Case Western Reserve University School of Law. We usually do a CLE program in conjunction with our Law Alumni Advisory Board, and that meeting was scheduled for today, and so we decided to do an online webinar as a CLE program, trying to stick with our tradition of doing a program in conjunction with that meeting. Obviously, we are doing this remotely because of COVID-19. And today what I'm going to talk about is how COVID-19 has affected the Supreme Court, a little bit about the current term, and then about the presidential records cases, which are certainly quite significant, quite monumental, and will possibly be the most important cases that the court decides this term. So let me share my screen so I can put up some slides for everybody and so folks can see what we're going to talk about. So we're talking about the Supreme Court. Not much has changed outside the Supreme Court as a result of the pandemic, but certainly things have changed inside. Normally, as I think many of you know, the Supreme Court does not allow photos, let alone video, of oral arguments. There aren't pictures of the justices in the court during an argument. So if you went to any of the oral arguments that have been held recently, this is what you would have seen because the justices were not there. The arguments were not done in person. COVID-19 has not only affected our lives as individuals, as lawyers, it's affected the operation of the courts. Now, when I talk about the Supreme Court, I like to start just saying a little bit about the current court. I think understanding a little bit about the current court puts things in perspective. I usually also like to start with some trivia, pick people out of the audience, test their knowledge of the Supreme Court. I'm not going to do that here, but I am going to still do some trivia, even if I'm not going to put any of you on the spot. Here are our current 9 justices. Here are some details about them. The oldest justice is Ruth Bader Ginsburg, who is 87. The youngest is Justice Neil Gorsuch, who is 52. And you can see when they were confirmed, which president appointed each justice and their current ages. A few little bits of trivia, again, because I think this is fun, even if I'm not putting any of you on the spot and giving you flashbacks to your law school days. Which justices were Supreme Court clerks? Think about it for a moment. Any ideas? Well, it turns out 5 justices on the court were clerks. The majority of the justices on the court were clerks on the Supreme Court. Chief Justice Roberts clerked for Chief Justice Rehnquist, and Justices Breyer, Kagan, Gorsuch, and Kavanaugh also clerked on the court. Which justices have experiences in all 3 branches of government? This, I think, is worth thinking about because in the presidential records cases, one of the big underlying currents is how do we think about the executive branch and its relationship to the legislative branch? And it's certainly understandable that a justice's experience, having worked in the executive branch or having worked in the legislative branch, could affect how they see that balance of power and how they see the interests that are at stake. So any thoughts there? All right, well, if you guessed Justices Breyer and Justice Thomas, you would have been correct. Those are the 2 justices that have experience in all 3 branches of government. They are the 2 that have spent time working for Congress. Justice Breyer was a committee staffer for Senator Ted Kennedy. Justice Thomas was a staffer in the office of Missouri Senator John Danforth. They both also worked in the executive branch, as have quite a few justices on the Supreme Court. Justice Kavanaugh, Justice Gorsuch, Justice Kagan, Justice Roberts, Justice Alito, all have experience in the executive branch at the federal level. Justice Sotomayor has some executive branch experience as well, and that is worth noting. Which justices were prosecutors? This might be an issue in the second presidential records case, or the third, depending on how you count the Trump versus Vance case, because that concerns efforts to obtain documents by the DA of New York. And so think about if you know which justices were prosecutors. Well, if you guessed Justice Sotomayor and Justice Alito, you'd be correct. They were both federal prosecutors. I suppose if you want to get nitpicky, you might argue that Justice Kavanaugh was a prosecutor as well, because Justice Kavanaugh worked for Kenneth Starr in the independent counsel investigation of President Clinton. And so in that respect, he was a prosecutor as well, although not a traditional criminal prosecutor. He did argue cases involving access to presidential records and privileges, and was involved in the impeachment report that was submitted to Congress. Which justices were district court judges? This is something in general I think is important when we think about the range of experience on the Supreme Court, whether or not there are justices that have experience in district courts, and particularly if you're thinking about how does grand jury information work and when it might be admissible or what have you, that sort of experience we might think is important. Well, we have just one. Justice Sotomayor is the only justice currently on the Supreme Court who has experience as a trial court judge. And again, if we think about how the court evaluates certain sorts of claims, the fact that she's the only one with that sort of experience, that might influence how the court approaches some of these questions. Now, here's a good one. Which justices were criminal defense attorneys? You could think a long time on this one because the answer is zero. Some of the justices do have experience doing work for criminal defendants at the appellate level, such as filing habeas petitions with the Supreme Court. Those justices that worked as appellate attorneys have that kind of experience. It's common for Supreme Court attorneys to do that sort of work on a pro bono basis. But in terms of actual on-the-ground criminal defense work, we don't have any currently on the court. And again, that might affect how we think the court understands certain sorts of arguments or the interests that are at play in certain cases. Last one, which justices have held elective office? Again, I could give you a lot of time here. The answer would be the same, none. No current justice has held elective office. Again, some have worked for people who in elective office, but none of the current justices have actually stood for elective office themselves. The last justice on the Supreme Court who had held an elective office, I believe, is Justice O'Connor. She had been a state court judge and had been held elective office at the state level in Arizona. So that's enough with trivia. We've got lots to cover. So let's move on a little bit. This is our current court. We often think about it in terms of a block of more liberal justices, a block of more conservative justices. The Chief Justice, most people think, is likely to be the median justice. That is the justice that it most likely casts the deciding vote in 5-4 cases, particularly when the court is split along these lines. That may be true going forward. It might not. Last term, that did not appear to be the case. There was at least one case last term, at least one 5-4 case last term, in which each of the conservative justices joined with the 4 liberals to form a 5-justice majority. So it'll be interesting going forward to see if this understanding of the court, it continues to hold sway. Something I think it's worth noting out, the court, here's a very small docket, and this term, the number of cases will be shrunk even more because several cases were postponed until next term. The court does a lot less work than it used to in terms of the number of cases. It also means that the cases that it hears are increasingly really the hardest, most difficult cases coming through through our federal court system. In 2018, we had only 67. Again, it looks like this term we will have even fewer than that. In terms of some broader trends in the court, this is just some data that I think is interesting, looking at the split of the court. For each term, there's a set of bars. The first one is 9-0 decisions, then 8-1, 7-2, 6-3, 5-4, and then the last one is 5-4, where the court is split along ideological lines. What's worth noting is those two trend lines are the running averages for, or the trend lines for unanimous decisions and 5-4 decisions. We'll see if that holds this term. I think there's a reason that we might see quite a few 5-4 decisions this term. A higher percentage of the court's decisions are likely to be 5-4 this term than in recent years because of some of the cases that the court has. But I think this is worth noting because the Chief Justice has said that he wants more unanimous decisions. He certainly behaves in a way that he leans towards 9-0, 8-1, 7-2 decisions. We've seen some evidence that he's been successful at that, but there certainly have been terms like the 2018 term and perhaps like this term where the number of 5-4 decisions has really increased significantly. A couple trivia questions about this current term. This is a term in progress, but which justice has been in the majority most often this term? Think about that for a second. Up until 2 years ago, we would have said Justice Kennedy. Almost every term had been correct because Justice Kennedy was in the majority more than any other justice over the past 10 years. Almost every year, he would be in the majority more than any other justice. His replacement, Justice Kavanaugh, though, so far this term is batting 100%. I doubt that will go through for the rest of the term. It would be quite remarkable. But thus far this term, he's batting 100. In terms of justices that have agreed the most this term so far, we have two pairs, Roberts and Kavanaugh, and then Breyer and Kagan. Each of those pairs have agreed in 98% of the cases, at least in terms of outcome, not necessarily in terms of the entirety of every opinion or decision. I assume this number will go down as the court decides the remaining cases this term. Truly last question I'm asking you, which justice has written the most opinions this term so far? Think about it for a second. Justice Ginsburg is usually the first justice to write an opinion. She, in most recent terms, the first opinion of the term is written by Justice Ginsburg. She's usually very quick. But in terms of volume, Justice Thomas, he's written 17 opinions so far this term. Only 3 of those are majorities. He's written 8 concurrences and 6 dissents. He is increasingly prolific as a justice. In terms of the current term, we've had some significant decisions so far. What could have been an important Second Amendment case ended up being dismissed on mootness grounds and is an important mootness decision. We had a very important Clean Water Act ruling earlier this term in County of Maui versus Hawaii Wildlife Federation. For those of you with an interest in environmental law, a very important case about the scope of the Clean Water Act, and a case in which the position advanced by environmental groups largely prevailed, which is unusual in this court. A case involving PROMESA, which is an entity Congress created to help Puerto Rico deal with its financial situations. Unanimously, the court rejected a constitutional challenge to the composition of that. But if we're talking about important cases, this term has a ton of them that have yet to be decided. And that we hope and expect will be decided by the end of June, although the court might not stick to that usual schedule. We have a set of cases involving the scope of Title VII, the federal anti-discrimination statute, and whether or not the prohibition on discrimination on the basis of sex in employment includes discrimination on the basis of sexual orientation and on the transgender status of an employee. So there's a set of 3 cases that raised those 2 questions and they were argued at the very beginning of the term. They have yet to be decided. We have a case challenging the Trump administration's rescission of DACA, deferred action for childhood arrivals, one of the Obama administration's immigration reforms. The Trump administration rescinded that. We have a constitutional challenge to that was argued back in November, still yet to be decided. We have a significant case on aid to religious schools out of Montana, the Espinoza case, We are waiting for that case to be decided. A case challenging the constitutionality of the Consumer Financial Protection Bureau. This entity was created in the wake of the last financial collapse, and there is an argument that the composition of this entity, and in particular, the fact that it is headed by a single individual who is protected from removal without cause, whether or not that structure is unconstitutional. We're waiting for that decision. There's a significant abortion case, June Medical Services out of Texas, concerning restrictions placed on abortion providers. These were all cases argued prior to the coronavirus outbreak, all cases that we are still waiting for decisions on. So there's a lot going on at the Supreme Court. Some of these cases might be decided as early as Monday, when the court will issue additional decisions. But as you can see, this is, if I just stopped here, we would say, wow, what a big term, what a really important Supreme Court term. But there's more. Since the coronavirus outbreak, there are additional cases that have been argued. They've been argued remotely, and I will talk about that in a minute. But we have a case concerning the so-called contraception mandate, or the obligation of employers to provide contraception coverage, and its applicability to religious employers or other employers that may have moral objections to providing for contraception. The Trump administration adopted a rule accommodating religious employers and those with moral objections, and there is a challenge to the scope of that rule. There is a case involving the scope of something called the ministerial exception. This is the idea that religious entities, and in particular institutions of worship, are to some degree exempt from federal anti-discrimination statutes, and there's a case involving the scope of that exception, particularly in the educational context. We have a case that's held over from last term that, quite frankly, is about whether or not half of Oklahoma is still what we think of as Oklahoma. There is a case called McGirt, in which the claim is that existing tribal claims were not ever properly extinguished, and as a consequence, certain prosecutions of Native Americans for crimes allegedly committed in what amounts to close to half of Oklahoma were invalid. A very significant case, one the court clearly struggled with. They originally heard argument for that in 2018. Justice Gorsuch was recused, so we generally think the court may have been split 4-4 in that case. They said they would re-argue it, and then they heard a companion case from which Justice Gorsuch is not recused, that will, in some respects, deal with Oklahoma remains Oklahoma as we know it, or whether or not certain tribal claims have to be recognized. Two cases involving faithful electors, whether or not members of the electoral colleges have to follow the instructions provided them by the voters on election day. The court heard two cases related to that. Case that could be very important. I don't know about you, but I'm certainly one of those people that likes to think that a faithless elector case will not be important. I'd like to think we won't have a presidential election that's so close that one or two electors deciding to change their votes won't make a difference. But it's in these polarized times, I suppose that's possible. And so this case is potentially important. And then, of course, the cases that we'll spend some time digging into today, the cases involving presidential papers, or really I should say presidential financial records. The three cases, two involving congressional subpoenas, one involving the grand jury subpoena about the president's financial records. So when you look at just this term and its significance, and you look at the subjects that the court has been dealing with, and I haven't even mentioned the immigration cases the court has dealt with this term. There was an important age discrimination case this term, an important standing case. This term, just in terms of the substance of what the court is dealing with, I think it will go down as one of the most important Supreme Court terms, certainly of the past decade, perhaps of the Roberts Court, just in terms of the volume of high-profile, important matters that the court is dealing with. And then if that weren't enough, we had the emergence of coronavirus. The COVID-19 pandemic has caused the court to suspend arguments for the first time since 1918. The court had also suspended arguments in the 1790s, but it's very rare for the court to do something as severe as suspend arguments. It did that in 1918 during the outbreak of what we generally call the Spanish flu, and it did so this year. It suspended oral arguments in March and April, and then in May of this year, it held telephonic arguments in a subset of the remaining cases, and it rescheduled the rest of the cases that were supposed to be argued until next term. This also, I think, is very significant because this is something that is so rare, and it may be causing changes in the way the court behaves and the way the court conducts its business that will be long-lasting. And that's certainly worth noting. In terms of the impact of coronavirus on the court, if you just look at the rate at which the court has been issuing decisions, this is data that's put together by the folks over at SCOTUS blog, a really invaluable resource for information about the Supreme Court. And if you look at this data, the bold yellow line is the rate at which opinions were issued last term. The blue line that stops partway through, the solid blue line, that is the rate for this term. The court is behind. So if you feel that as a result of COVID-19 and working at home or having to change your work conditions hasn't led to a burst of productivity, well, it hasn't for the Supreme Court either. They are behind last term's rate of issuing decisions. And as I've already noted, there's just a wealth of big ticket opinions to be decided. So the court has slowed down some and pushed some cases to next term, so it won't even decide as many cases as it has in recent years. As I noted, the other switch that we've seen is the court switched to telephonic arguments for some of the cases in May. It heard arguments over the phone, and that was a difference in the way this court has operated historically. The Supreme Court does not allow cameras in the courtroom. Traditionally, it records oral arguments, but it does not release those recordings until the Friday afternoon of the week in which the argument was heard. So with the Supreme Court, most arguments, the Supreme Court, are heard between 10 and 12 in the morning, and then a transcript is usually released that afternoon, and the recording that is made is not released until the end of the week. That stands in stark contrast to a lot of other courts. A lot of other courts make audio available much more rapidly, and increasingly courts at both the federal and state level are live streaming audio, and in some cases, live streaming video. Some federal appellate courts began live streaming video even before the COVID-19 pandemic, but not the US Supreme Court. So for example, the Texas Supreme Court, here's a picture of the Texas Supreme Court conducting oral argument over Zoom. And it seems to have worked okay for them. Here at Case Western, we did our moot court tournament through Zoom. The students on our moot court board did an amazing job using this technology to create judicial chambers and breakout rooms and to present oral arguments. So we know oral arguments can be done this way. That's not been the path that the Supreme Court has taken. What the Supreme Court has done, because it's doing telephonic argument, is it has made those arguments available to the press in real time. So one consequence of COVID-19 is that for the first time in our nation's history, we heard live audio from the Supreme Court. We heard the arguments as they were occurring. The first case to be heard is a case involving Booking.com, a trademark case. That was the first case that the Supreme Court allowed live audio. And if so, of course, one question will be going forward, given that live audio worked, I would argue it has been a tremendous benefit in that for these cases, and in particular the cases I'm going to talk about in a minute, we've been able to hear the live audio. This has been really good in terms of court transparency, allowing people to actually understand what's occurring at the court in real time. I think that's been a good thing. And we see this in lots of important cases, real-time audio. The DC Circuit this morning heard real-time audio in the case concerning the Michael Flynn prosecution and the Justice Department's effort to dismiss the charges against Michael Flynn. The DC Circuit made live audio available, as lots of courts do. In terms of the Supreme Court making live audio available, some things that are different about what's been done as a result of that, and I'm going to pull up the Q&A box. So if folks have questions, they can start putting them there, and I can get to them as they come in, or I will save them for the end. So if you have a question, you can put that in the question and answer box, and I will try and get to those, or you can put them in the chat box. But in terms of the Supreme Court, since we're talking about questions, one thing that has been very different about telephonic arguments has been the way it has affected the questioning that occurs at oral argument. I put a slide up with Justice Thomas on it quite deliberately, because Justice Thomas rarely asks questions at oral argument, and he's explained that he thinks the advocates don't get enough time to make the arguments they want to make, that his colleagues seem to be tripping over each other sometimes to get their questions in, and he doesn't feel the need to participate in that. A change in the way the Supreme Court has been operating is that instead of a free-for-all, the Supreme Court allows the advocate to get a couple minutes at the beginning without questions, and that's a reform that was adopted about a year or so ago for all oral arguments. But then the justices ask questions in the order of seniority. And so the Chief Justice asks the first questions of each advocate, and then it goes to Justice Thomas, and it goes through the justices. And Justice Thomas has been a very active questioner. And one of the things we've seen is he's been a really incisive questioner. Having listened to all of the arguments, it's worth noting that he has often set the tone of the questioning, that he has raised questions that get followed up by his colleagues quite regularly. And having his own questioning time, Justice Thomas has taken advantage of that. I think all the justices have tried to take advantage of that. Now, it creates a very different dynamic, because one justice gets their few minutes to ask questions, field the responses, or hear the responses, ask a follow-up, and they don't have to worry about being interrupted by one of their colleagues. The flip side of that is that if Justice Thomas asks a question and Justice Sotomayor, who's several justices down the line of seniority, wants to follow up on those questions, she has to wait till her turn. And that may affect the flow of the arguments. For myself, I think this has been a positive development. I think the quality of the questioning has actually been better. I think that the depth of the inquiry has been better, but it's definitely different than the sorts of oral arguments we've heard in the past. It doesn't mean that there haven't been hiccups. There have been cases where justices forgot to unmute themselves. I'm sure many of you have had experience on Zoom or Skype or other platforms where you want to enter into a conversation and people don't hear you, and you have to then find your unmute button. That's happened to the justices as well. There also was a mystery. There was a mystery flush that Slate Magazine, an online publication, actually devoted a lengthy article trying to investigate and determine which justice was responsible for the sound of a flushing toilet during oral argument. So justices are people just like the rest of us. They sometimes don't handle the technology as well as they could. But overall, I think this experiment with telephonic arguments has been very positive for the court. It's really helped access to the court in terms of letting people hear oral arguments. It's allowed journalists to write their stories or broadcast their stories with the actual audio, relying on the actual audio. It's allowed students and other people interested in the courts to listen in real time or shortly thereafter. They don't have to wait till the end of the week for the audio. As an educator, I think it's been a tremendous step forward, and I certainly hope that the court learns that despite the one errant flush, that allowing live audio is a plus, and that when the court returns to oral arguments at 1 First Street in the Supreme Court building, I certainly hope the court will consider keeping live audio. I think that would be something that's very good for transparency and very good for, in particular, for cases as charged and as sensitive and as high profile as the cases I want to turn to, the cases involving the president's records. Again, these arguments were heard telephonically. They were heard on the same day. The two cases, Trump versus Mazars and Trump versus Deutsche Bank AG, were heard in consolidated argument, and then Trump versus Vance concerning the grand jury subpoena were heard that same day, right afterwards. What I want to do is I want to walk through just some of the key issues in each of these cases, highlight some things that I think are important in terms of the way the court is going to decide these cases, what seems to be important to the justices. Again, if you have questions that pop into your mind, feel free to put them in either the chat session or in the question and answer box, and I will certainly try and answer those questions either as I go along or at the end. But I do want to get through this material because we want to keep it to the hour that is scheduled. So let me start with the Trump versus Mazars and Trump versus Deutsche Bank AG. These are cases involving congressional subpoenas for the president's financial records. They involve subpoenas from 3 separate House committees: the House Oversight Committee, the House Financial Services Committee, and the House Intelligence Committee. Each of these committees have subpoenaed financial records from those entities that have those records. So banks like Deutsche Bank and Mazars, and they've sought these records from the third parties that have these records. So unlike a lot of fights over other sorts of documents, unlike, say, the efforts by Congress to get former White House counsel Don McGahn to testify, these are cases seeking documents, but they are the president's personal financial records. They are not White House documents, and they are documents that are being held by third parties. And that the fact that they're being held by third parties has some interesting implications. On the one hand, it means that the White House can't claim that it is burdened as an entity by having to respond to these requests because the White House isn't the one responding to these requests. On the other hand, the president's lawyers have argued that because the subpoenas were not filed against the president hasn't been in a position to negotiate with the committees over what documents could be revealed and what documents could not be revealed. Instead, Donald Trump's lawyers went to court seeking to quash these subpoenas. So the way these cases arose is after the subpoenas were issued by Congress, Donald Trump in his personal capacity filed suits trying to block the enforcement of these subpoenas, basically saying to Mazars and Deutsche Bank, don't release these records. The banks, for their part, have said basically they will do what the courts tell them to do. So these cases involve the financial records of the president, bank transactions, financial records, not just of Donald Trump, but of his family members. These are very broad subpoenas. So it's those family members involved with the Trump Corporation and their direct family members. So if Barron Trump has a bank account and has a credit card, those records are part of the subpoenas. So these are incredibly broad subpoenas of the sort that we haven't seen very much historically. Of course, we also historically have not seen a president with the sort of financial dealings and alleged financial improprieties or suspected financial improprieties as the current president. So there's a lot about this that is unprecedented. The key question that the court is focused on is whether or not these subpoenas are for a legitimate legislative purpose. There is no provision in the Constitution giving Congress an oversight power. Congress's power to engage in oversight, to subpoena information, is generally characterized as an implied power. The idea is that for Congress to enact legislation regulating banks, enforcing the Emoluments Clause, regulating ethics in government and conflicts of interest in government, that Congress needs information. Congress needs to understand what's the nature of the problem that we are trying to address and what sort of legislation will most effectively address that problem. And so it has always been understood since the nation's founding that Congress has at least some authority to demand information, to subpoena information, as well as to hold individuals in contempt for failure to comply with those subpoenas. And this has always been understood as something that Congress has the power to do. The question that's being put to the court here really is, to what extent are there limits on that power? To what extent does Congress have to be able to identify a legitimate legislative purpose for the subpoenas? And if it has to identify such a legislative purpose, to what extent are these subpoenas, as broad as they are, justified by a legitimate legislative purpose? And we'll come back to that idea of, is there a limit on legislative purpose? Because I think that's something the court is particularly concerned about. Now, when we think about Congress investigating the president, I think we often want to think about Nixon, and we think about President Richard Nixon. At one point, it seemed like the court might be interested in having us think about a different Nixon, Walter Nixon. I don't think he's any relation to the former president, but Walter Nixon was a federal judge who was impeached and removed and challenged the constitutionality and lawfulness of the impeachment procedures that were used against him. This case went to the Supreme Court in a case called Nixon versus United States, and the Supreme Court said this is a political question. This is about the legislature overseeing the judiciary. We're not involved. If the legislature believed it followed its processes, we have nothing to say about it. And before oral argument in the Mazars and Deutsche Bank cases, the Supreme Court asked the parties to brief whether or not this should be seen as a political question, whether or not this should be seen as simply a question to be fought out between the legislative branch and the executive branch that the courts would have no role in. And it was a provocative question, because one thing it would mean is it would mean that federal courts could not quash the subpoenas. So the cases brought by Donald Trump seeking to quash the subpoenas to the banks would be dismissed for lack of jurisdiction. And so the banks would simply have to decide, do they want to comply with the congressional subpoena or risk inherent contempt on their own. It also, though, would mean that if Congress were to subpoena the president directly, or subpoena, say, the White House counsel, as has been done in another case, which is still in the lower courts, that courts would not enforce that subpoena if Congress sought to see that subpoena enforced. So it was a provocative question. Supplemental briefs were filed by all the parties on this question. None of the parties in the case wanted the court to resolve this on political question grounds. They all wanted an answer on the merits. And the oral argument, the court did not, will not be answering that question. There is a quick question on about the slides. We will put slides up on the website, and I will be providing CLE information at the end of the program for those that are watching this live. The Nixon case, the case of Walter Nixon, was not as significant in this case as some thought it might be. Another recent circumstance that actually does relate a lot to the current situation is the Whitewater investigation and the various congressional investigations into President Clinton. That is the case where we see the closest example of congressional subpoenas like the ones that were filed for President Trump's records. That is to say, if we're looking for a case in which a congressional committee sought financial records and of a sitting president based on actions the president may have conducted in his private capacity, including prior to becoming president, we do see some subpoenas like that during the Whitewater investigations of President Clinton. But importantly, while President Clinton asserted various privileges and mounted legal challenges to many aspects of the independent counsel investigation into him, and whether Whitewater or the Monica Lewinsky matter and the like, President Clinton did not challenge the subpoenas seeking financial records. So we don't have a court decision, let alone a Supreme Court decision directly on point to the Mazars and Deutsche Bank questions. Now, at oral argument, representing the House of Representatives, whoops, where's my slide? There we go. Douglas Letter represented the U.S. House of Representatives, and I think most observers think that his argument did not go well. That he really faced more skepticism across the board from quite a number of justices, not just the more conservative justices, about his claim that these congressional subpoenas are all justified by a legitimate legislative purpose. In fact, at one point, or actually I shouldn't say one point, at several points during the argument, he was asked by different justices what the limit is. If Congress can ask for all of the president's bank records and the president's children's bank records and their credit card records, if that serves a legitimate legislative purpose, what wouldn't? And Mr. Letter had a very difficult time answering that question. And he was asked that question by multiple justices. At one point, he suggested that maybe the personal medical records of the president might not be something that Congress could subpoena with based on a legitimate legislative purpose. But then he backtracked a little because he noted that if Congress is going to enact legislation, say, concerning the 25th Amendment and how to determine when a president is incapacitated, or Congress wants to adjust the rules of presidential succession. So what do we do when a president leaves office or, heaven forbid, dies in office? That might actually justify looking at the president's medical records. And then as Donald Trump's attorneys noted in their rebuttal, one of the arguments that Congress has made for accessing these records is that looking at the president's finances and allegations of financial improprieties might be a useful case study for looking at how to regulate the financial system. And as the president's attorney noted, if that rationale works, well, then why couldn't the president's medical records also be a case study? And I think it's important to note that these questions did not simply come from the conservative justices. They came from some of the liberal justices as well. Justice Breyer, for example, during oral argument, said to Mr. Letter, my problem is there may be burdens here, third party or not, and not just political burdens. The job of the House and Senate, in part, as the president, is politics. That doesn't bother me. But the Clinton versus Jones information does bother me. And the fact that what I hold today will also apply to a future Senator McCarthy asking a future Franklin Roosevelt or Harry Truman exactly the same questions, that bothers me. So what do I do? I think the reason I highlight this particular passage from oral argument by Justice Breyer is it highlights that the court is very much focused on what the rules should be for what the House can and cannot subpoena, what Congress can or cannot subpoena from the president, what are the limits of legitimate legislative purpose. And it suggests to me, at least, that there is probably a majority on the court that is concerned about the breadth of the subpoenas. And while a majority of the court, I would think, believes that Congress has legitimate oversight power here, that there is widespread concern about the breadth and about the need to identify a limit. And as I noted, the counsel for the House of Representatives, Doug Letter, had a hard time identifying a limit. Now, I should note, that may be that he didn't anticipate the question. It may also be that his client, the House of Representatives, didn't want an answer to that question. The House of Representatives might not want to have acknowledged a clear limit on its authority. So we don't know whether or not this was a failure of advocacy or a consequence of the interest or direction of the client. But I do think it's notable that many justices seemed interested in this question of what is the limit? Can Congress seek your financial records? Can it seek my financial records? What information about the president is beyond the scope of congressional oversight? One thing that's also worth noting about this oral argument is something that did not come up. And something that did not come up, really, is impeachment. The way these cases were argued below is that the relevant House committees argued that they have the authority to issue these subpoenas based upon their power to engage in legislative oversight, that this is adjunct to its Congress's legislative power. They did not claim that these subpoenas were justified on an exercise of the impeachment power. And, for myself, I find that to be particularly interesting because certainly one could argue that financial conflicts of interest while in office could rise to a high crime or misdemeanor, could potentially justify impeachment, and that that is something that Congress should be able to inquire into. But that was not the basis upon which these subpoenas were authorized. And so based on the briefs, based on oral argument, that's not something the court's looking at. The court's not looking at what could Congress demand as part of an impeachment inquiry, but as part of a legislative inquiry. One other point, in the Nixon impeachment, one of the things that the House raised as a basis for impeachment was the failure to provide demanded documents. So that itself could be a basis for engaging in an impeachment inquiry, the failure of the executive branch to turn over documents. But again, not an issue in this case. This case is focused on what can Congress do when it is engaged in legislative oversight, or at least when it says it's engaged in legislative oversight. Now, the Mazars and Deutsche Bank cases are quite distinct from the Trump versus Vance case, and I think they're actually a little more difficult than the Trump versus Vance case. I think the Trump versus Vance case is or should be an easier case. If you listen to the oral argument, I think you hear the justices, again, across the board, more skeptical of the president's position in the Trump versus Vance case than they were in the Deutsche Bank and Mazars cases. This case is about New York grand jury subpoena for the president's financial records and tax returns. And again, the president's attorneys seeking to block that subpoena. And the claim of Donald Trump's lawyers here is, their claim is that the president is absolutely immune from state criminal process while the president is in office. It is an incredibly broad, almost breathtaking argument. The Justice Department filed a brief which is more limited. It's not reaching the immunity claim, but rather saying that when a grand jury is seeking documents of the president while the president is in office, that the threshold showing that the grand jury should have to make, or that the prosecutor should have to make to get those documents, should be higher than the usual requirement for grand juries. So while the Justice Department is arguing against these subpoenas, the Justice Department did not embrace the really broad absolute immunity argument. Now, in my listening to oral argument, I didn't hear any justice that I thought was sympathetic to the absolute immunity argument. There were some justices that may be concerned about what the precise threshold or showing should be. And I thought that the attorney for the Manhattan District Attorney's Office made a very powerful argument that the lower courts here concluded that the relevant showing was made, that the showing for the need for these documents that needs to be done was made, and so that even if the court thinks there needs to be a slightly greater than normal showing, that has been satisfied. The case that really is the most important case for thinking about Trump versus Vance is Clinton versus Jones. Clinton versus Jones, if you recall, was a civil suit brought by Paula Jones against Bill Clinton based on conduct he engaged in prior to becoming president, so not based on any official conduct. And the court in Clinton versus Jones said that we have never suggested that the president has an immunity that extends beyond the scope of any action taken in an official capacity. The president is certainly legally immune for official acts, but President Clinton's alleged sexual harassment of Paula Jones was certainly not official conduct. It occurred when he was governor, or is alleged to have occurred when he is governor of the state of Arkansas, not when he was president. The Manhattan DA is looking at alleged and potential financial improprieties and potential financial crimes that may have been committed by Donald Trump, the Trump Organization, or its associates, not official actions by President Trump. There is language in Clinton versus Jones that made clear that this was a case in federal court, that it wasn't reaching state court proceedings, it wasn't reaching criminal proceedings. But the language of Clinton versus Jones, which was unanimous, is that to the effect that we don't have a king, we have a president. That the president, as a person, is a person and is subject to legal process like the rest of us. And while the court acknowledged that the president has the ability to say or to push back against particular information demands, push back on the scheduling of a deposition, and has arguments that the rest of us would not be able to make about the need to protect the president's time and ability to function as president, and that courts would have to accommodate and take into account those particular sorts of claims. That's all about the proceedings. That's not about immunity. That's just about recognizing that the president may have scheduling or other interests that have to be accounted for. And I think that logic, as applied to Trump versus Vance, would suggest the same, that the president personally might be able to resist a deposition more effectively than the rest of us, and the like, but that the president is not immune to criminal investigation. And certainly the president's organization and family members should not be immune to investigation. There is an argument, one that I think is correct, that the president could not be indicted until after he leaves office, and certainly could not be prosecuted until after he leaves office. But the claim here is not about that. The claim here is about the grand jury. And as you all know, the grand jury may be investigating a wide range of conduct. And maybe it's not Donald Trump that the grand jury concludes should be indicted, but his accountant or one of his children who also works in the Trump enterprise. And that the grand jury needs to be able to investigate fairly broadly. In terms of what's going to happen, I'm reluctant to give predictions, but let me say a few things. One, we don't know when these cases will come down. Usually, when we don't have a pandemic, the Supreme Court is very good about getting its cases done by the end of June. If you're cynical, you'd say the justices like their vacations. They recognize how oppressively hot Washington, D.C. can be in July and August, and they like to get their business done and leave town. But normally, all oral arguments are finished in April, and that gives the justices plenty of time to finish their opinions. This term, I would not be at all surprised if we are still getting opinions in July and perhaps even later. I think that it's going to be very hard for all the cases, and especially these cases, to be finished up by the end of June. In terms of how the court will decide them, I think that I'm wary to give predictions, but I think that the court seemed unsympathetic to Donald Trump's arguments in Trump versus Vance, and so I would be surprised if the president's arguments win there. I think the court seemed more sympathetic on the margin in the Deutsche Bank and Mazars cases. And again, I think Justice Breyer's concern there is the real one. The court is really concerned about where you draw the line. I could certainly see the court laying down a standard or a test for how to determine whether or not the scope of a congressional subpoena is within the scope of legislative authority. And perhaps then sending it back to the lower courts to determine that. One thing I can predict with some certainty is that we will have opinions both Monday and Thursday of this coming week, but I can't tell you which opinions they will be. Unlike some courts, the Supreme Court does not tell us which cases are going to be decided on what days. There is a question in the chat about what was Kavanaugh's role in gathering information from Clinton with regards to Whitewater and Jones cases. Brett Kavanaugh was on the staff of Ken Starr. He was involved in litigation concerning some of the various privileges that Bill Clinton raised. He, if I recall correctly, even argued or in oral arguments in some of those cases. He was also involved in drafting portions of the impeachment referral. So he was very involved in those cases and has an understanding of that. It's worth noting that Elena Kagan worked in the White House counsel's office during part of the Clinton administration. So she is aware of what it can do to an administration to be under extensive investigation, as I think it's clear the Clinton administration was. And so that's another way that I think the Clinton experience weighs on the justices. Another way, which I didn't mention before, is that in the Clinton versus Jones decision, Justice Breyer wrote a concurrence saying that he worried the court was not being sensitive enough to the fact that a president's political enemies or political opponents could try and use litigation as a way of harassing the president, if not trying to take the president down. And there's no question that some of the attorneys that were involved in the Jones case, some of the people that were helping Paula Jones with her case, were antagonists of the president and were folks that wanted to see if Bill Clinton could be removed from office. And Justice Breyer was concerned about that, about the number of cases that could eventually be brought. So I think as a consequence of Justice Breyer's opinion and what we've seen since, I do think the justices are going to try and be sensitive to what is the rule they create in each of these cases and how does that affect matters going forward. The president's lawyers raised the prospect of, I think it's 2,300 district attorneys around the country filing claims against the president. Now, I don't find that argument that persuasive because they need jurisdiction. The Trump enterprises are in New York. So the New York DA has jurisdiction. It's not clear to me that, say, the prosecutors here in Cleveland would have jurisdiction of the sort that Cyrus Vance is asserting in New York. On the congressional side, though, we have seen increasing partisanship. As much as the Clinton administration and Bush administration were investigated by Congress, the Obama administration was investigated even more, and then the Trump administration even more than that. And I think that is a perspective that folks will be worried about. I see we are at the bottom of the hour, so I want to wrap up the official part of this program. I'll hang out a bit and happy to answer questions in the chat. But if I was just going to give a closing thought, this term is a momentous term. It's a term that, for all the reasons I've talked about, the court is considering an incredibly large number of monumental cases with significant implications. That by itself would have made this a monumental term, but we've added to that the court having to adjust the way it operates as a result of a pandemic, and that some of those changes in the way the court operates could certainly change the way the court behaves going forward in terms of access to arguments and the way arguments are structured. And then we have these truly monumental cases concerning access to the financial records of a sitting president. It is really a momentous time. As folks like to sometimes say, that the screenwriters for 2020 really outdid themselves. And we'll be talking about this term for a long time to come. Thank you.